At this time, we're going to ask for a reset. As the court is aware, I recently ran for election and won. When I'm receiving a certain level of retaliation from the outgoing DA's office, I anticipate filing motions to recuse the DA's office on all of my existing cases. Those will come shortly, but at this point, Ms. Curry has prohibited my access to the assistant DAs. So any cases that do not have an offer or that need negotiation, I can no longer do that with the assistant DAs per her order. So at this point on any case that is not resolved, I'm going to ask for a reset and give me an opportunity to file a motion to recuse and set those for hearing.
State.
Judge, I think you would have to do that anyway going forward come January 1st. But the fact of the matter is, he is still open to speak about plea negotiations with Ms. Curry.
So Ms. Curry going to come to court and do that so we can do business?
She certainly, if she needs to be here, yes. But we don't have pleas. He reached out to her yesterday afternoon, is my understanding, when that comes.
Well, and Judge, I would object to Mr. Hernandez speaking on that at all. He has no personal information of my discussions with Ms. Curry. At the end of the day, I asked her yesterday if she was going to appear in court today, since she is the only point of contact. She did not respond to that. So ultimately, my point of contact for the last 3 years has been Mr. Hartwell. Ms. Curry has informed me that I am not allowed to speak to assistant DAs, including Mr. Hernandez, about any pending cases. Further, she stated in writing that any communications I have with that office have to be through her, and they have to be in writing. I did send her a list of the docket and said, make me offers then. So far, I have not received any. Now, I don't expect to, and that is where I'm at today. So ultimately, I have 85, 90 cases pending that have to be resolved between now and January, or else the DA's office will have to recuse themselves. She is going to do, apparently, anything she can do to prevent me from doing that. We cannot conduct business that way. It's unnecessary, and it's specifically geared towards political retaliation based on her own words. So at this point, I'm dead in the water as a defense attorney, and she's affecting all of my clients. She's affecting the function of this court, and I believe that her actions are malicious in nature, and ultimately I'm going to seek other remedies. But as of today, the only remedy that I can come up with, the quickest remedy, is to file a motion to recuse her office based on those grounds. Now, those motions haven't been filed yet, so the court doesn't have anything to rule on, but I'm giving the court a heads up that that's what I anticipate doing.
So you don't have any offers on any of these defendants that are here today?
I have offers on a couple. There are quite a few that there are no offers. There were a couple that were going to be set for plea. I do not have any plea paperwork at this point. I don't know that if it's forthcoming or not. I don't anticipate it to be forthcoming based on the exchange I had yesterday with Ms. Curry, and she chose not to show up here today. So at this point, she's trying to hamstring my ability to conduct business.
Judge, we can have her here in a matter of minutes. I can certainly reach out to her if necessary, but if negotiations aren't happening prior to court.
It's okay.
Well, I just don't appreciate the grandstanding, Judge.
I don't care about that. Get Ms. Curry here so we can try to do business. If there's fighting between Ms. Curry and Mr. Schmidt, that's something that can occur other time. I've got defendants that are here. They need offers. They need counter offers. They need rejections. She's the only one that's willing to do it. She needs to be here every docket that Mr. Schmidt's here. If she's not going to give you the authority to do it, she's not going to give Mr. Hartwell the authority to do it, and she needs to be here. So call her and tell her to get over here.
And Judge, if I may.
That's okay. That's okay. We'll continue this when she gets here because I want to hear from her on this. And I think she has the right to be heard on it. So, Mr. Buchanan, I'll recall your case. I'm sorry that you're in the middle of this, but all of Mr. Schmidt's comment, we'll get to the bottom of it. So thanks, sir. It's great. Are you ready? Mr. Buchanan, come back up. This is cause number CR 25-196, State of Texas versus James Larry Cannon for docket call. Mr. Schmidt, you made an announcement earlier regarding plea offers with Ms. Curry. Any follow-up?
Well, that's correct, Judge. I made the record earlier on this case specifically, Mr. Buchanan. I know Mr. Hartwell has made an offer. I anticipated further negotiations with Mr. Hartwell. He's no longer permitted to negotiate with me. So under the circumstances, I anticipate prior to either a resolution or announcement for trial, sitting down with Ms. Curry. I hope that works out. But as of today, we would ask for an additional docket call.
Ms. Curry.
There it is.
Your Honor, yesterday via email, I informed Mr. Schmidt, and he sent an email to Mr. asking for plea offers and a long list of cases. I responded by informing him, cases that were set today. I responded by informing him that number one, we were past the deadline for today. And number two, that in the future, all plea offers from this office would come to him in writing, and they would come through me. His response was, great, sounds good, thanks for the response. I had no idea he was upset with that till he got here today. In fact, he said he appreciated my response and would look forward to offers. I told him that I would give them to him in the future, but that we were too late for today. I don't know what changed since the last email yesterday.
Mr. Schmidt made a statement earlier that he doesn't have access to Mr. Hartwell or Mr. Hernandez, meaning that he can't negotiate with them regarding any of his cases, offers, counter offers, discovery issues. Is that true?
All negotiations will be in writing and they will come through me. He's welcome to email them as long as he includes me, and any response from us will come through me.
So you know that that's going to necessitate the court needing you to be present on the announcement of these cases. That way, if he announces an issue or asks for something that your assistant DAs can't address, that's going to necessitate you being here on Mr. Schmidt's cases.
Judge, it has been our long-standing policy during my term as DA that we do not negotiate on court days. All negotiations have to be done prior to that. Tuesday dockets, there's a Thursday deadline. For Thursday dockets, there's a Monday deadline. So there's no necessity for negotiations to happen here in the courtroom. They'll happen via email in a timely manner.
But I'm talking about for announcements. So if I
Our
ask,
staff will be well aware of what they will be just as current as they are now as far as announcements go. I will be here when necessary, but
no disrespect, but my experience is they've not been prepared when you've handled cases. Most defense counsel come in here and they say, I've been working with Ms. Curry on this, and Mr. Hernandez and Mr. Hartwell don't have notes. They haven't been able to make announcements. They don't know. Is that going to change? If they're going to be in a position where they can announce, then great. But my experience has been these gentlemen haven't been able to. They've either had to reach out to find out what's going on, or defense counsel. Usually defense counsel comes in and says, oh, I've been working with Ms. Curry specifically on this, and they've asked for a reset or something, and the assistant DAs haven't always been. I would say majority of the time haven't been able to address it.
I suspect maybe defense counsel was doing that as a method of defense, not aimed at Mr. Schmidt. I believe I know.
And I think you're right.
Yeah, I believe
there's a handful of attorneys that like to say that.
No, my assistants will be involved in all those emails. They will know what's going on.
Very well. All right. So as for Mr. Buchanan,
As for another docket call, Judge.
any objections from the state?
No, Your Honor, I believe there was the offer previously made at Mr. Buchanan's plea, and all prior plea offers are still good, Judge. That was conveyed to Mr. Schmidt yesterday as well.
And what was the plea offer that's been made to Mr. Buchanan?
For TDC.
For TDC?
Yes, sir.
All right, court will set Mr. Buchanan for a final docket call July 7th, Mr. Schmidt. Sure, I got it.
Yes, sir.
Make sure I got my Tuesdays, Thursdays running.
Yes, sir. And just for the record, for the court's information, I still anticipate following through with filing those motions on all of these cases. I don't believe that this resolution is workable based on my communications with Ms. Curry. And ultimately, when we file those, we'll ask for a hearing and we'll go from there. But as of today, I anticipate this is going to be an ongoing problem, and it's going to prohibit us from conducting business effectively. But hopefully that's not the case. Hopefully we will be able to work that out.
Well, why it would be a problem, Judge, if he timely emailed us? I don't know why it would be a problem.
Okay. Understand. If you file motions, then you'll notify Ms. Abraham and we'll set them on the docket.
Yes, sir. Thank you.
Your next case, Mr. Schmidt.
Susanna Frisbee.
Ms. Frisbee, CR 25-230, State versus Susanna Aurora Frisbee. Is this a plea today?
No, sir.
We were separate plea though, correct?
We were set for a plea, Judge. The state has revoked the offer that they made for Ms. Frisbee, so we'd ask to set her on a docket call. I'll discuss the case with Ms. Curry, hopefully, and we'll see if we can resolve it.
Judge, in this case, we had previously made a plea offer. That plea offer has been withdrawn due to the behavior of Ms. Frisbee, and we're asking that she be UA'd.
All right, court will order that the pretrial release officer conduct a urine analysis exam on Ms. Frisbee, and the court will set Ms. Frisbee then for a final docket call on July 7th. On that day, she can announce acceptance of a plea agreement or a request for a trial. I do show that Ms. Frisbee is delinquent $270 on pretrial release. But my understanding that Ms. Frisbee also has CPS issues. Is that correct?
She's got an ongoing CPS case, yes, sir.
Okay.
And at this point, since the state has revoked their offer, we have no offer. So I would anticipate receiving one of those from Ms. Curry shortly.
All right, so Ms. Frisbee, you're going to sign. You're not free to go yet. The pretrial release officers are going to test you, and then you're not to leave after your test. You're not to leave the courtroom until the court directs you one way or the other, okay?
And Judge, completely unrelated to our discussions just a few minutes ago, but because of the actions of Ms. Frisbee while she's been on bond, we don't anticipate a plea offer in this case.
Understood. Thank you.
And Judge, that's just for the record. I mean, that's exactly the problem we're going to have ongoing. Not to have an offer on a case such as this is anathema to doing business in this courtroom.
Judge, she had a plea offer. She has continued to engage in behavior that indicated that that plea offer was not appropriate. We withdrew it. It's for reasons none other than her own action. We will likely not make a plea offer in this case.
Understand.
And Judge, from that perspective, what we'll do is we'll announce ready for trial. Because ultimately, if they're not making a plea offer announced by Ms. Curry, then there's no purpose in continuing Blackballs. This is what I'm talking about. So if we could get a trial setting.
Sorry. As I have said, it has nothing to do with our prior conversation. This was a decision that was made a while back in consultation with our CPS lawyer. It has nothing to do with anything that Mr. Schmidt and I have been talking to the court about on other cases this morning. It is solely based on her own behavior.
Understand.
Not indicative of how other cases will be handled unless those defendants also mess up.
Understand. Court notes that the state is free to make offers, revoke offers, not make offers at all. So do you want me to set her for final docket call, Mr. Schmidt, or do you want me to set her for a jury selection?
Well, based on the state's announcement, I guess jury selection.
All right, court sets Ms. Frisbee then for jury selection. Beginning June 22nd. So Ms. Frisbee, your case will not be reached for trial on the 22nd, but you will make an appearance that day. Staff will meet you downstairs. You'll check in with the pretrial release officer, and you will continue to report until your case is set for trial. Mr. Schmidt may or may not be down there because he's not going to be required to be there until your case is set for trial in the top 10 cases, okay? But today, I still need you to submit to your analysis exam and not leave the courtroom after your testing until directed to do so. You understand?
Yes.
Do you want to go back there, Judge?
You need her? Yes, go with Officer Chook.